Welcome to History Bites, a monthly video series produced by George Mason's Gunston Hall for people who want to learn about their rights and how those rights have changed from the American Revolution to today. We find experts and we ask those experts to make their research easily digestible in 30 minutes or less. I'm your host, Dr. Kate Steir, and today we're joined by Dr. Holly Brewer, who will be discussing her research on the peace treaty that ended the American Revolution and how some of the practical considerations that helped to keep that peace undermined the revolution's highest ideals. Holly Brewer is the Burke Chair of American Cultural and Intellectual History at the University of Maryland and Associate Professor of History at the University of Maryland. She is an inaugural member of the Historians Council on the Constitution at the Brennan Center for Justice at NYU Law, and her specialty is in early American history and the early British Empire. So, to set the stage for what we're going to talk about, George Mason wrote the Virginia Declaration of Rights in the early summer of 1776, before the start of the American Revolution as a war. Property rights were a huge focus of the Virginia Declaration of Rights. Two separate articles outline an individual right to property. And Article 11 talks about trial by jury as being the best means of enforcing property rights when disputes arrive. And so this question of the legal mechanisms for enforcing and safeguarding property rights were a central concern to the founding generation. And that became only more true as Virginia shifted from being a British colony to a state in a newly independent American republic. And these questions are at the core of the debates that Dr. Brewer is going to be leading us through today. So without further ado, I'd like to turn it over to her. Thank you for joining us.
Thank you so much for having me. I'm going to share my screen just so you can see a little bit of a few examples from the primary sources I'm going to talk about today. And what's so interesting about what I'm going to be retracing for today is the tension between property rights and human rights that you see exemplified, first of all, not only in George Mason's in Virginia's Declaration of Rights that George Mason wrote, but also in the Declaration of Independence. And one of the fascinating things to me about the Declaration of Independence, and here you see the initial draft being presented on that first day with Jefferson handing it over to George Washington in this would be in June of 1776. But the initial draft of the Declaration had strong language condemning slavery, calling it a violation of the most sacred rights of life and liberty. And one of the fascinating things to me, especially, is how the word men here is all in caps and italics, which referred to Africans. And especially when you think about the language at the beginning of the Declaration about all men are created equal, there's no question that, at least in this draft, that Jefferson was crucial in drafting, Thomas Jefferson, that there was this sense that African people had rights too. So there are these big tensions that are brought out in the debates leading up to the revolution over which rights are more important. And I'm gonna give you just a little bit of a background about how people came to be seen as things, as property in the British Empire. And it's a little bit complicated. I'm not going to go into depth at all with this, but feel free to ask questions afterwards. At first, in England's empire, in the New World, they were cobbling together feudal law, so medieval law from the Middle Ages. But by the latter part of the 17th century, as the royal family, and particularly the king and his brother, James, Duke of York, got involved directly in the slave trade, set up a Royal African Company. They created a better legal foundation for slavery that said that essentially people could be things. So this is the seal of the Royal African Company, an announcement. Royal African Company was having difficulty establishing ownership even in terms of debts. And so this is a document related to that. And this is a fort owned by the Royal African Company off the coast of Africa that helped enable the slave trade. It was expensive. It involved the royal use of the Royal Navy. And part of the reason that the British kings supported slavery and supported making people into property in terms of that was because of the huge income that came to the British Empire from essentially what we would now call tariffs on all the goods that were shipped there. And especially enumerated goods, which included tobacco grown in Virginia and Maryland, were very heavily taxed in England, and they had to be sent back there. And they were mainly grown by slave labor. And so the kings of England in the 17th century were actively pushing larger estates and bound labor that would grow more export crops because they were taxed. So what happened is in 1677, this guy, he was Chief Justice of the High Court in England. His name is Richard Rainsford. Ruled in a decision that applied across the empire that was called Butts versus Penny, 1677, that if people were aliens, if people couldn't swear an oath of allegiance to the king, then they weren't subjects, or what we would now say is citizens, right? They were aliens. And if they were aliens, they were outside the protection of the law. If they're outside the protection of the law, they could be considered, they didn't have any rights, and they could be considered things and not people. So this is where you get the legal category of people being things. It's from this case in 1677. And England, by the time of the Revolution, had about 40 colonies in the Americas. Only 13 of them rebel in the up here. There's a lot more down here. There's 6 up in Canada. But during the Revolution itself, slavery was really destabilized. And in the treaty that ended the war, there was a clause in there that ended up kind of protecting slavery. And it's not only in America itself with the Declaration that slavery was being challenged, or the idea that people were being property was being challenged. It was being challenged in England itself as well. So in 1773, there's another high court case that actually overturns Butts versus Penny very deliberately. It's called Somerset versus Stewart. It's a really famous case about freedom in England, but it doesn't necessarily apply in the empire. Partly because parliamentary laws were also established by the 18th century that said people could still be things in terms of the repayment of debts. So the question is, like, what happens after the Revolution, and how does these older understandings of people as property get fixed in American law after the Revolution when there really had been part of English or British law? And the answer is that the Treaty of Paris that ended the Revolution in crucial ways protected it. And that's kind of blurry. It's the last page of the treaty. These are some of the British authorities who were crucial in negotiating that treaty. And you can see them here trying to repair the empire in a cartoon from 1784. But this guy, his name was Richard Oswald, was really important on the British side in negotiating that treaty. And he was actually a partner in the slave trade with Henry Lawrence. He was one of the Americans who signed the treaty from before the Revolution. And he and Lawrence got together to make sure that debts from before the Revolution, which had often been lent to purchase slaves, and which were owed to British merchants, would be fully repaid according to the terms of the treaty. And so what you get is in Article 4 of the treaty, you get a clause that says explicitly, it is agreed that creditors on either side shall meet with no lawful impediment to the recovery of the full value in sterling money of all bona fide debts heretofore contracted. And that was put in by Richard Oswald. If you track the documents, Richard Oswald and Henry Lawrence. It's actually almost the first thing negotiated in the treaty. Henry Lawrence introduces Richard Oswald to Benjamin Franklin, and that starts the rest of the negotiations, and the king's on board, and it's all very important. But this is actually really crucial. And it doesn't say slaves, but the main asset, the main collateral for most of those debts from before the Revolution were enslaved people. And Article 7th also related to slavery, and it said any people who had joined the British cause, the English promised them freedom, who were enslaved, and that the British had, that they were supposed to send them back. So there are two clauses explicitly related to slavery, and this is them. And just to give you a sense, in Virginia, where they passed a manual admission law in 1782, it still said, partly as a result of this treaty, that you couldn't free someone if you had any debt. So for planters, who most of them had huge debts from before the Revolution because of how the mercantilist system had worked before then, they knew they couldn't free someone if they had a debt. And in fact, there are later Virginia court cases that say by 1805, there's a really important one that say that if you free an enslaved person and you have debt, anyone to whom you owe a debt can capture that person and resell them into slavery and keep the money. So what does this mean afterwards, and why is this important? And what I found with my research is not only everything that I've just explained, but that this part of the Treaty of Paris gets upheld by a Supreme Court decision in 1796 that people haven't really connected at all to slavery, or in fact to Thomas Jefferson, to which it directly connects. So I'm going to just talk through a tiny bit. I've just got a few minutes to overview a lot, so I'm doing this really quickly. But this is the first page of Jefferson's farm book, where he kept track of the number of slaves he owned, etc. And as you see here, on January 16th of 1774, he records a roll of the slaves of John Wales that were allotted to TJ and right of his wife on a division of the estate on January 14th, 1774. So these are the people, the enslaved people, who Jefferson inherited with his wife from his father-in-law, John Wales, in 1774, along with a ton of debt. And Virginia passed a law in 1777, the year after the Revolution started, saying that you could pay your debts into the Virginia Treasury, which Jefferson, among other people, did. Any debts you owed to British merchants. So some of these debts that he inherited, for which these enslaved people were collateral, he, at great effort, paid off into the Virginia Treasury in 1777. But, sorry, my screen is not, there it goes. Some of them ran away as well. But what happens, what I really want to talk about now for the last 7 minutes, is this Supreme Court case from 1796. So between 1783, when the Treaty of Paris was signed, and 1796, Jefferson was one among many who were trying to make sure that they did not have to repay those debts and that their former payments into the Treasury counted. And he actually went and tried to renegotiate that part of the treaty with British authorities in 1786 on his way to France to be the ambassador. Totally not successful. After the federal government is set up under the Constitution and federal courts are set up in 1789, these cases began to be litigated. And this case, Ware versus Hilton, is the first one to hit the Supreme Court, to where they weigh in on this question. And it literally involves Thomas Jefferson's own debt, for which slaves are collateral. And Ware is the administrator of Jones, and you can see here is the William Jones, who was part of Farrell and Jones, to whom John Wales, Thomas Jefferson's father-in-law, owed a lot of money. And Francis Epps is Thomas Jefferson's brother-in-law and co-heir of the estate. So This case is actually literally about Jefferson's debt, but also impacts Virginia planters generally. And basically what it says is that all of the money that was owed to British merchants has to be repaid in full according to the terms of that original treaty, and that they're also going to have to pay interest and penalties for not having paid it earlier. And why it's in that federal law, and especially a federal treaty law, is superior to state law, and so it struck down the state law from 1777. What this meant in terms of Jefferson was that the money he paid into the treasury in 1779 and 1780, which paid off a big chunk of the debt that he owed, was now no longer good. And Virginia had refunded him a tiny portion of the money based on the face value of the paper notes that he put in. And that was not even by 1799, when he got it back, worth even a part of the interest he owed on the debt. What this means in the biggest possible terms is that this court case was upholding what I've called elsewhere a common law of slavery, of property as people. And that not only that, in upholding the debts in full, along with interest, etc., it meant that in practice, a lot of the enslaved people in Virginia literally belonged to British merchants who were the landholders. So think about it in modern terms. If you buy a house using a mortgage, you kind of own the house, but the bank kind of owns a house too, right? So in this case, what this meant is all those merchants really had a stake in every enslaved person in Virginia almost, as a result of this case. And the case was argued for Jefferson and Epps, Francis Epps, by John Marshall, later Chief Justice of the Supreme Court. And he makes a really powerful argument that does not win the day, but that there were a lot of land confiscations during the Revolution of the land of people who were Tories on the grounds of treason, and that this debt, because these payments had been made before the treaty, should be treated similarly under Article 6 of the treaty, not Article 4, and that it was an ex post facto rule. So in other words, the treaty was signed in 1783, but these debts were paid earlier, so it shouldn't have applied. Anyway, he makes a really good case. He loses. Part of the reason he loses is because of intense renewed pressure in the 1790s by the British Crown to implement this part of the treaty or face renewed war against Britain. And that's what Jay's Treaty is also all about. So I'm going to end with just a quick observation about its impacts, the impacts of this court case, and what it means to really understand that the revolution was incomplete, that the Supreme Court this treaty and the Supreme Court were upholding an incomplete revolution. They were upholding in some ways Britain's continuing power, and also this older notions of repayment of people as property, and that all the debts for which slaves had been the collateral would still be intact. What it means in practical terms is that a lot of the planters in Virginia suddenly had a lot more debt than they thought they had in 1796. I mean, partly in 1783, but especially after 1796. And in the spring of that year, St. George Tucker, one of the most important Virginia jurists at this point, had written a proposal for the gradual abolition of slavery, like was happening elsewhere in other states, like in Pennsylvania. They had passed such a law. New York would pass such a law. They had not yet passed it. And this is what got rid of slavery in most of the states in the North. In the spring of 1796, they were debating it as a real possibility in the lower house of the Virginia legislature. But once this decision came down from the Supreme Court in Ware versus Hilton, which hit about May of 1796, it became this proposal was basically dead, because most of the planters who were present in the legislature were all of a sudden facing much steeper debts for which their slaves were collateral, and it made even considering this much more impractical. practically it made it much harder to try to live up to the ideals of the revolution. And I'm going to stop there.
Great. Thank you so much. And I do have a question for you from the chat. So some of our viewers are interested in this concept of an incomplete revolution and would like to know, where can they go to learn more about this idea or to understand more fully the ways in which the revolution was incomplete?
Well, I I'm just publishing a book. It's going to come out with Princeton. It's called The King's Slaves, and I do talk about that in the last two chapters. But most people don't use that category. We tend to just sort of, I think, almost naively think of, oh, it's a revolution and there's a peace treaty and it's all over and America is no longer connected to Britain. But what you see is, working through the courts, this conditional nature of the treaty and essentially British justice being imposed on Americans after the revolution. So I I think unfortunately it's not yet published. It will be out in about 9 months. But I'm just trying to think if anyone else has framed it exactly that way. And I don't think they really have. It makes sense when you look at it, right? And especially when you think about, well, when you look very closely at Ware versus Hilton, it says in its text that the treaty law is more important than state law, and where it's a state law, right? So it's been implicit there all along, but people don't teach it that way. They talk more about Americans being more radical or more conservative, or the founders not wanting to do as much as they might have done. But in fact, what you've got is also the deliberate imposition of continuing restraints by the British Empire, which was still very powerful.
That's such a fascinating point, because I feel like I've seen this discussed sometimes in terms of like federal control versus states' rights. But thinking about that idea of federal law as being part of government to government relations and therefore beholden to this larger international order, which kind of undermines in some ways this notion of what does it mean to be an independent nation
Right.
in what was still a very heavily integrated Atlantic world. So I think for me, that's one of the really fascinating things that your research sort of brings out, and also opens the door to understanding about the early republic.
Right.
Yeah.
That I think we want to imagine almost that America was always this really powerful nation, but of course in the 1790s they're still pretty weak. And I think that treaty could have turned out differently after the Battle of Yorktown. In particular, the English were more in a vulnerable position, but I think some of the treaty negotiators like Benjamin Franklin and John Adams did not realize what they were agreeing to with Article 4. Like, it seemed reasonable on its face, and they didn't realize the depth of the debts that were existing in the South, and that most of those debts had slaves as collateral. If that makes any sense.
Absolutely. And I think that also highlights the differences within shifting from these 13 colonies that have or had in some ways really different sort of economic systems they were built on, and different understandings of their relationship with the crown. And so all of a sudden trying to come up with a single sort of legal framework for their relationship to Britain as a single entity reveals some of that misunderstanding. People coming from Pennsylvania who didn't have the same kind of monoculture economic system weren't necessarily reading the same kind of subtext or understanding.
That's exactly right. Yeah,
Yeah.
they didn't realize the implications of what they were committing the Virginians to. Now, Henry Lawrence knew, but he was also pretty unique, partly because he'd been involved in the slave trade as a factor for some of the big British importers. He was really wealthy, and people owed him money from England. But he was in an almost unique situation compared to many of the Virginians. And one of the amazing things is John Rutledge was the same person who, in the Constitutional Convention in 1787, when the possibility of of challenging slavery was brought up directly, he was the one who said, if that is done, South Carolina is not part of the Union. So he was the one who made that threat.
Oh, wow. I had not
Yeah,
realized. And
yeah.
I mean, one of the things I really enjoy about the story you're telling is, so as someone who thinks a lot about the 18th century and the founding period, people ask all the time, sort of, what would the founding fathers have thought about X, Y, or Z? And to me, the answer is always, well, which one? And
Yeah, I
sometimes
know
even
exactly.
at which particular moment.
And that's exactly right too. Yeah.
Yeah. And so I think part of what this teases out, that's so fascinating, is all of these different competing goals, some of which are very practical, and this question of how to like physically sort of run this new country, and how are different laws going to be settled and debates settled and relationships handled, and also these questions then of these larger ideals that really animated this kind of shared vision, but at the same time, how shared was it, and how to actually bring it into alignment. So I think that's one of the things that the way you handle this case is so instrumental in kind of telling us about the American Revolution.
Yeah, and the limits in which many of them were operating. We almost want to think like just they're living in this world made new and they can do whatever they want, but they can't. And they're all, here, Thomas Jefferson, later president, this person who wrote the Declaration of Independence, you'd think the law maybe wouldn't apply to him, but he was completely burned by this decision. And that's just one example of how the larger forces are operating, right? And
Yeah,
but more to the point, the people who were enslaved were especially burned because it foreclosed these possibilities, keeping in place really powerful international financial arrangements that made everything much more difficult.
absolutely. And I think it also speaks to this question of what slavery's role in the early republic was, because this is of course a huge debate, and to be able to see the ways in which all of these different actors were actively sort of questioning and deciding what are the economic implications of this, what are the political implications of this was something we can see through the primary sources, through your research, people really wrestling with and debating, and not sort of in a unified understanding or
Exactly.
accepting.
The
Yeah.
debates were really intense. It's utterly fascinating. I think I mentioned to you beforehand that the person arguing the case on behalf of Jefferson and Epps was John Marshall, the future Chief Justice of the court. And he gives this incredibly powerful argument for why those debts should have been regarded as paid, and that they were good, that payment was good, and the state law was should be upheld. And when you see, and you can imagine him giving that speech, and this is the only case he argued before the Supreme Court, and he's later chosen Chief Justice. So even though he loses in that case, people clearly respect him. And so you almost get this sense of, yeah, how things could have been different. And if they'd known what this might have meant in later on in terms of making it much more difficult to get rid of slavery in Virginia and elsewhere, and how this, it's would they maybe have decided differently. I don't know.
Yeah, I could talk to you or about this all day, because it just opens so many different kind of possibilities of understanding this past. But I did promise our viewers 30 minutes or less, so we're running low on time. And I do want to thank you so much for joining us. So we got a little bit of a preview of a book coming out in about 9 months or so.
From
Is there?
Princeton.
Yeah, from Princeton University Press. Okay,
Mhm.
everyone.
It's called The King Slaves Creating America's Plantation System. And basically says that the English and later British Empire had a much more important role in creating this system than we have understood. And then it wasn't just happening on the ground in the colonies. There was a powerful empire behind it, along with legal systems.
So be sure to pre-order that. Get your libraries to pre-order that.
It's not around yet, but yeah, but not yet. But
Yeah. And is there anywhere else where people who want to learn more can follow you or your work or check out more
well, if they
you've
want to
done?
get into the weeds of understanding this first court decision that I mentioned, Butts versus Penny, I have an open access article called "Creating a Common Law of Slavery," which is pretty readable if they're interested. Um, and there's well other things that have been published, but I guess that's the main thing that relates to this particular talk. And it is a little dense. On the other hand, it shows that even in 1677 there were active debates.
Absolutely. Well, thank you so much. I'm going to reread some of your articles after this in light of kind of what we've been discussing. And I want to thank you and I want to thank our audience for joining us. So for those of you tuning in, we'll see you back here with another feast for your brain on the third Wednesday of next month, which will be September 17th. And at that point, we'll be joined by Alyssa Feder of Rising Organizers, who will be talking to us about how civic engagement and community organizing relates to constitutional rights and the original individual rights outlined in the Virginia Declaration of Rights. But in the meantime, please feel free to like, comment, subscribe to our channel, watch this video over and over again so you get all of the little Easter eggs, and keep the conversation going on social media. As always, stay hungry and we'll see you soon.
Thank you so much for having me. Thank you for coming and listening.
Thank you.
Okay.